Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Denver, Colorado, and you're watching All Up in Your Business. In this episode of All Up in Your Business, I'm going to talk about liability to LLC members, what it means and how it can come up. Because I've found that there's a lot of confusion and misunderstanding about LLCs, specifically single member LLCs, and how the members can individually be liable for something, and how liability of the members can come up. So I'm going to dispel all those myths about liability protection from an LLC and let you guys know really what it means to be a single member LLC and how that might affect you. But before we get into it, please be sure to like, subscribe, and share. And don't forget to check the description for links to some additional information and resources. And you can also download my free guide on how to pay yourself in a single member LLC. So really quick, before I get into the meat of this video, I want to explain, I'm licensed in Colorado. My knowledge and my expertise really is Colorado law. And I know some stuff about other states, but laws are very different from state to state. So the things I'm going to be talking about in this episode are primarily based on Colorado law. However, the general concepts and the general ideas are, for the most part, consistent through all the states. But I just want you all to keep in mind that the words that I'm going to be using and the things I'm saying won't necessarily specifically apply to you if you're not in Colorado. So when we talk about LLCs or even corporations, these LLCs and corporations are distinct legal entities, separate from their shareholders or their members, separate from their owners. One distinct primary advantage of an LLC or a corporation, comparing this to something like a general partnership or a sole proprietorship, the owners and the managers have limited personal liability for the company's debts. And so what this means is that the shareholders, the members, the managers, the people who own and operate the business usually can't be held responsible for the liabilities or the obligations or the debts of the company. They usually can't be held personally responsible for those things. But under the right circumstances, or rather under the wrong circumstances, a court may decide to hold the individuals or an individual owner responsible for those debts and obligations. Of course, an LLC member, the main reason we start an LLC is because we want to protect our personal liability. And we want to insulate and protect our own assets like our home or our personal bank accounts, our personal retirement accounts, and those things. That's why we do the LLC in the first place usually. And there are two concepts which are closely related, but they're very different. Two concepts that come up when we talk about personal liability and liability for business debts that come up. And this is where the confusion often arises, because these two concepts are related, but they are very, very different. And what I'm talking about is piercing the corporate veil versus charging orders, which is another commonly used term when we're talking about liability to individual business owners. So like I said, business owners will generally form a corporation or an LLC with the intent of insulating and protecting and limiting their personal liability. But sometimes a court will hold that member personally liable for the debts of the LLC. And this situation is called piercing the corporate veil. If a creditor of the LLC sues the LLC, the court might pierce the corporate veil and decide to hold the member personally liable for those debts. I've talked a lot about piercing the corporate veil in previous videos, so I'm not going to go into too much depth about that. If you want more info on piercing the corporate veil, you can check to some of these videos. but I'm not going to go into too much. But piercing the corporate veil, this term corporate veil, it applies to corporations and LLCs. And specifically in Colorado, as it applies to corporations, the law says, unless otherwise provided for in the Articles of Incorporation, a shareholder, I'm reading it so I don't get it wrong. This is what the actual law, the statute says. Unless otherwise provided in the Articles of Incorporation, a shareholder of a corporation is not personally liable for the acts or debts of the corporation, except that such person may become personally liable by reason of the person's own acts or conduct. So basically what that's saying is, by law, by default, shareholders of a corporation aren't personally liable unless they may be held liable by reason of their own activity or conduct. And as a general rule, that same protection extends to limited liability companies and members of LLCs. But there's a notable exception in Colorado statutes where it says, in any case in which a party seeks to hold the members of a limited liability company personally responsible for the alleged improper actions of the LLC, the court shall apply the case law which interprets the conditions and circumstances under which a corporate veil of a corporation may be pierced under Colorado law. Okay, what does that mean? Basically, that's saying that courts can take the corporate concept of piercing the corporate veil and apply it to limited liability companies and apply that same concept. So really what those two statutes are saying in Colorado is that we take the same idea as it applies to corporations and we apply that to LLCs when we're talking who's liable for corporate debts. Again, I've gone into this in more detail in other videos, but the overarching idea and the concept of piercing the corporate veil is separateness between the business and the owner themselves, or the owners themselves, and this theory of alter ego, and is the business just an extension of the owner themselves. And so if a court determines that this separation hasn't really been kept and that there was some improper use of the LLC by the members, then the court may decide to pierce the corporate veil. And then in that case, the LLC's creditors can proceed against the members' own home or bank accounts or investments or other assets that the individual member has. So now let's take that piercing the corporate veil and compare this to charging orders, which are very different things. So even if an LLC doesn't get pierced the corporate veil, if the veil stays intact, a charging order still allows attachment of an LLC member's interest in the LLC. So to illustrate this, let's use a couple of examples. Let's say I go on a shopping spree. We're still kind of in quarantine from COVID-19 right now. I'm bored at home doing an online shopping spree, and I rack up $10,000 of debt on my personal credit card. If I refuse to pay this legitimate debt that I have personally incurred, then a creditor, that credit card company, my creditor, can sue me in court and try to obtain a charging order to be able to collect on that debt. And so in every state, a creditor can go after the members or an individual's personal assets for legitimate personal debts. So creditors can garnish wages. So that's the typical method that we think of. But then in some states where these charging orders are allowed, it also gives the creditor a right to obtain an interest from the LLC. And how it plays out differs between states. But in Colorado, it's kind of like a wage garnishment, except it's on the members' distributions. So it's essentially getting a garnishment of the LLC members' distributions that they would be entitled to. So in other words, let's say I've got $10,000 of credit card debt that I legitimately racked up, but I refuse to pay. A creditor can get a charging order against me and my LLC. And now any distributions that I might have taken from my business, the creditor is entitled to take those instead. So it's like a wage garnishment where they're getting their hands on the money before it is able to get to me. Again, it differs from state to state. Some states will extend a charging order only to the LLC members' distributions. Some states will go a little bit further and give the creditor more of a right to step into the shoes of the LLC member. It differs depending on the state, but that's the general concept of the charging order. So let's compare that. Let's say in that first example, I spent that $10,000 on my personal credit card and I'm refusing to pay it. If I had done that shopping spree on my business credit card, now I'm mixing, I'm muddying up that separateness between me and my business by using that credit card that's for business expenses, by using that to buy clothes for myself. Now I'm ruining that protective veil of limited liability. And that's what might expose me to risk of piercing the corporate veil. So I hope that makes sense. I hope you guys are able to grasp the difference between member liability for the LLC or the corporation versus this concept that a member and an LLC can still have some shared liability. Because the fight back, the argument usually when I talk about piercing the corporate veil or avoiding the risks of a single member LLC, and when I talk about how to take these steps to protect your personal liability, I get feedback and arguments saying, no, you can't, no, that doesn't work. You can still always be responsible. Like the LLC is still liable for a member debt, blah, blah, blah. And that's not true. A LLC, even with a single member LLC, is still a good and viable way to protect your personal liability as a business owner. It's not, and it has never been, a way to avoid actual legal obligations or responsibilities. And that's what piercing the corporate veil is all about, is making sure that we're not abusing the limited liability that an LLC or a corporation gives us, and that someone is still being held responsible for legitimate debts. And so that's where piercing the corporate veil comes in, is holding someone responsible for legitimate business debts versus charging orders, where it's holding the member responsible for her legitimate personal debts. And we're saying this business of yours is an asset, just like your income or your wage might be. And so this creditor has a right to get at it and attach it some way in order to collect their legitimate debts. Truly, the moral of the story, whether we're talking about piercing the corporate veil or charging orders or any of it, the moral of the story is keep things separate between your business, because even when we're talking about charging orders, we still want to maintain that idea of separateness, but also just do good in your business, be a good person in your personal life, and piercing the corporate veil, charging orders typically won't be a problem for you. If you're not intentionally trying to avoid legitimate debts that you owe, then a charging order is not going to be a concern of yours. And if you're not using an LLC to avoid legitimate liability to yourself or to wrongfully give yourself some additional protection from actual obligations that you have, then it's not going to work. If you want more info on this, if you want to read a bit more about piercing the corporate veil or charging orders, check my blog. There's a link in the description. I've gone into a bit more detail about it. And then, of course, if you are in Colorado, if you're a business owner in Colorado and you have concerns about your own personal liability or piercing the corporate veil, please feel free to contact me. I'm happy to consult with you and chat and provide any help that I can. That's all for this episode, folks. Drop a comment below. Let me know what you think. And again, don't forget to check the description for links to download my free guide on how to pay yourself in a single member LLC. You can also check the link to visit my blog, where I go into a bit more detail on this topic of piercing the corporate veil versus charging orders and how those concepts apply to business ownership. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.